Many viewers send the following email. I think I have a medical malpractice claim, but how do I know for sure? Although this question seems simple enough, it actually is much more complicated. Joining us today to help navigate the waters is attorney Gerry Oginski, who, by the way, is visiting us for the second time.
Thanks for having me, David.
Thanks for coming back. It's a tough topic, and we were talking about nursing homes, and it's not always a slip and fall, but many times, if you're a resident of a nursing home, you're going to be a victim of medical malpractice. Am I correct?
Absolutely.
What type of malpractice are we going to be seeing in nursing homes?
You have malpractice where the physician is ordering something done and they fail to recognize that the patient has something going on. Or they misdiagnose something, or they don't send the patient off to the hospital in time, and now the patient suffers an ongoing problem that's never diagnosed.
Okay, how do you get involved? Again, is it a family member who reaches out to you? I don't assume it's one of the doctors at the nursing home.
No.
So how do you get involved here?
Typically, a child.
Okay.
One of the adult children will pick up the phone and call, and they'll say, Mr. Oginski, I think something was done wrong at the nursing home. I think something happened. And then I ask them two questions, which gives me a ton of information. I ask them, what do you think was done wrong, and what injury did they suffer as a result of that? And that gets them thinking, because contained within those two questions are three elements that we need in order to establish a case. What was the wrongdoing? Did the wrongdoing cause injury? That's known as causation. And what are the damages? What's the extent of the injury?
Now, when it comes to medical malpractice cases, they're expensive. Let's be honest. Okay, as opposed to many other types of cases, they cost attorneys a lot of money just to be able to bring these cases. Do you find that people are limited to being able to get into a courtroom because of this, or do you still see the same amount of medical malpractice cases that you've always seen?
The great thing about that question is that the injured victim and their family don't have to pay a dime to bring a lawsuit. Because the attorneys in New York, what they do is, if they find that there's a valid basis for a case, they will go ahead and lay out all the expenses up front. The attorney will be the one to pay all the expenses for the experts, to get the medical records, for everything that goes on during the litigation. And if they are successful at the very end of the case, then and only then is when the attorney will get reimbursed for all of those expenses, so the family or the injured victim doesn't have to lay out a dime to start a case like this.
What type of experts are you looking for in these, especially in these nursing home cases? I guess it could be an orthopedist, but who are you looking for? What kind of experts, really?
There are different types of experts, and here's what we need to do. Because in order to evaluate whether or not a patient or family has a valid basis for a case, we are required by law to actually have a medical expert confirm that, number one, there was wrongdoing, number two, the wrongdoing caused injury, and number three, that the injury is significant or permanent. And those experts could be a generalist, it could be a general practitioner, it could be a surgeon, it could be a geriatric physician. There are many different specialties, and we're required to get at least one of them to evaluate all the medical records to confirm that we have a valid basis before we can actually start suit.
Now, we touched on it before with our last expert, but how much time do you have to bring a case for medical malpractice in New York?
Well, generally, and there are many different variations, to bring a lawsuit against a private healthcare facility, you have only 2.5 years. But there's an important caveat, there's an important warning that people should know about. The warning is that not every healthcare facility or nursing home is a private facility. It may be part of a municipal facility, in which case you have a very limited time, and as of today, you have only 90 days in which to file a claim, and then only a year and 90 days in which to start a lawsuit. And by the way, if the loved one dies in the nursing home, the time limit is totally different. And so there are many different exceptions that can occur, and the only real way for somebody to understand what the time limit is or if their matter is timely is to pick up the phone, speak to an experienced attorney.
And it generally doesn't matter in terms of age, whether you're 50, 60. I mean, the statute of limitations is what the statute of limitations is. All right,
Correct.
So now once we're in the lawsuit, and you've started the lawsuit at this point, who are you deposing? Are you deposing the administrator, the doctor? Who do you want across from you?
Well, the great question is, first of all, some of these viewers may not know what a deposition is.
Okay.
And basically, it's really, as you know, it's a question and answer session that's given under oath. It's pretrial testimony. So the person that I want to talk to is, I want to talk to the doctor who is in care, who is in charge of the patient. I want to find out from them what they did, why they did it, and importantly, I want to establish what the guidelines are, what the baseline is. Because once I can establish from the doctor who is caring for the patient what the baseline standards were for treating a patient with this condition, now I can go ahead and review this particular patient's conditions and determine whether or not the standards fell below what's accepted or not. And that's how we use the doctor's own words and testimony to show whether or not there were departures from good care.
Now, are you going to have a problem if your own client either passed away or just is not able to testify, will you still be able to prove your case?
We can, and we do that using the facility's own medical records. And I know you talked earlier with Michael about whether or not the facility will keep accurate records, and that's something that we look at very carefully. But if the patient passed away and they're no longer around, then we look to see what other witnesses are around. Is a family member around? Maybe they have witnessed something. Maybe a nurse was there to witness as well. So we'll talk to each one of them to find out information about what happened and why.
Now, in terms of getting into a courtroom, do these cases generally settle? Or is there money that's offered before trial, or do you have to try most of your medical malpractice cases?
The reality is that most medical malpractice cases do settle. But the ironic thing is that of those cases that do not settle, the majority of those are taken to trial and are won by the doctor or the healthcare facility. That's a remarkable statistic.
Wow.
So you can't go by and, you can't just bring a case and say, let's just bring something, hope it settles, because they will fight this tooth and nail, and they have some great, great trial attorneys who are very experienced who you go up against, and it's not a pushover situation.
It's not.
Absolutely not.
Well, it's funny, you would think, as opposed to, maybe automobile accident cases, that, a nursing home issue where somebody is a victim of medical malpractice would be a very sympathetic case. But again, it's not a slam dunk.
It is sympathetic, and the thing that the defense attorneys like to do is they like to come back and say, you know what, but your loved one was elderly, they weren't contributing to society, there's not much compensation that we should be awarding to them because they were so elderly. But the reality is that there's often so much pain, so much suffering associated with what went on that led ultimately maybe to their death, that we can now show to a jury, and it's not so much extracting sympathy. It's getting them to understand and giving them a little insight into what went on. That's what gets them to understand, hey, there was significant pain and suffering that happened here.
Michael, who was here earlier, had talked a little bit about the bed sores and the pressure ulcers. Are you seeing that as one of the causes of actions in terms of injuries that are occurring in the nursing homes?
We do see that. And it comes up when a patient winds up being in bed for a long period of time. The nursing home is supposed to turn the patient over like clockwork. And they're supposed to do it at set times. And if they don't, and the patient is not in a specialized bed in order to try and limit and prevent these injuries, what will happen is that they'll develop these sores, they get bigger and bigger, and unfortunately, even if you try and treat them, they are horribly, horribly painful.
Okay, very quickly, I want to talk about your book. Tell the viewers.
Oh, this is a book that I wrote called Secrets of a New York Medical Malpractice Attorney.
And where can they get you?
They can get me at oginski-law.com. You can get the book on my website. It's a free download. It's a great book to read, very educational.
And you're going to come back?
I am.
All right. Well, that's all for tonight. It's time to deliberate. I'd like to thank all of our guests for joining us, and of course you for watching. Remember, if there's a legal issue or topic you would like to see on the show, email me at davidlesch@bronxnet.org. And until we see you again, always remember, know your rights, know your issues, reach a verdict. We'll see you next time.